Hello, this is Matt on the Moon Lambo channel. The appeal process in the SEC v. Ripple case is moving forward, but that doesn't mean that an actual appeal is going to happen. It just means that Judge Torres, at this particular moment in time, is allowing the SEC to file what's known as an interlocutory appeal, which is basically an expedited appeal request. So, I also want to state this right at the outset. This does not change anything about the legal status of XRP. Even if this ends up going forward and the appeal's actually approved, which is certainly not guaranteed, it's not going to change a damn thing about XRP. We got our win on July 13th. XRP is not a security. That is the law of the land. But I'm going to share with you perspective from several attorneys within the XRP community. Also have a comment from Stuart Alderoty, that's Ripple's chief legal officer, as well as a comment from Brad Garlinghouse, Ripple CEO. And in addition to this, Ripple did file a brief yesterday opposing the progression of this appeal status, and I want to share with you what attorneys had to say about that as well. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so at the time I'm recording this news broke, I guess, a little bit less than an hour ago. Here you can see from Fox Business journalist Eleanor Terrett. She wrote, "Breaking. Judge Torres has granted the SEC's request to file an interlocutory appeal in the Ripple case, timeline included." And I'm not going to read the whole thing. It's just a portion of a page. You can read it on your screen if you want to pause here. Just notes that Judge Torres has approved this. Shout out and credit to attorney James K. Filan for sharing what was yesterday breaking news. He wrote, "Breaking, Ripple files its opposition to the SEC's anticipated motion for leave to file an interlocutory appeal." And then there's also this. Eleanor Terrett had to say the following regarding Ripple's filing yesterday. New, Ripple files its response to the SEC's anticipated interlocutory appeal. The company, Brad Garlinghouse, and Chris Larsen opposed the appeal on the following grounds. Number one, the court's order does not involve a controlling question of law. Two, the SEC cannot show a substantial ground for difference of opinion. Three, an immediate appeal will not advance the termination of this litigation. And then separately, Eleanor did put out a reminder that reads as follows. Torres only granted the request to file. Now the SEC will have to come up with a compelling case to bring to the Second Circuit. Ripple will also have the opportunity to file its opposition to the appeal, which the Second Circuit will take into consideration. Here's what Stuart Alderoty, Ripple's chief legal officer, had to say about this. This was yesterday. He wrote, "We oppose the SEC's request for an interlocutory appeal. There is no extraordinary circumstance here that would justify departing from the rule requiring all issues as to all parties to be resolved before an appeal." And this actually, this next comment, this is from Brad Garlinghouse, and this really does illustrate the disgustingness of the SEC. Because what they're doing, in going after Brad and Chris specifically, is absurd given what Judge Torres has found regarding the legal status of XRP. But check this out. Brad Garlinghouse writes, "Reminder, the request for appeal, even if granted, doesn't change the fact that XRP is not a security. That's not up for debate/trial. But the SEC continues to claim that Chris and I acted recklessly in believing that XRP is not a security. That's utter nonsense." So pause to think about that. We know the legal status unquestionably today, XRP is not a security. That's it. So how could Brad Garlinghouse and Chris Larsen possibly have acted recklessly in believing that XRP is not a security when that is now the law of the land? Completely absurd, right? It's laughable. It's so stupid. And then Brad writes, the judge's July 13th ruling said that the SEC would be put to their proofs at the trial regarding their claim against Chris and me. We look forward to proving the SEC wrong as a matter of fact and law again." And folks, should it come to that, they're going to lose on all this stuff too. Here's what Attorney John Deaton had to say. And this is regarding Ripple's filing yesterday, opposing progression of this appeal. John says, excellent response. The even stronger argument will be coming next from Brad Garlinghouse and Chris Larson's attorneys related to the SEC's request for a stay. If it wasn't for the Rakoff ruling, I would lean toward Judge Torres denying the SEC's request to file a motion for interlocutory appeal. The SEC doesn't come close to meeting the standard justifying an early appeal. But with the Rakoff ruling out there, her allowing the SEC to write a formal motion will give her an opportunity to further demonstrate why her decision is sound and based on evidence, or the lack thereof, thus making her decision even more appeal-proof. And so, folks, I found that to be rather fascinating. Judge Torres may actually take advantage of the situation to just further expand upon the legal ruling that she's already put out there. And all thanks to this, well, at least in part, thanks to Judge Rakoff, the renegade judge, as Attorney Murphy put it, who contests part of what Judge Torres ruled regarding the SEC v. Ripple case. That would be fascinating. Separately, Attorney Deaton wrote the following. Remember, everyone, Judge Torres allowing the SEC to file a formal motion doesn't mean that she is agreeing to allow it to appeal. The immediate issue is only whether she allows the SEC to write a more detailed motion. For example, she allowed me to write a motion to intervene, asking her to force the SEC to formally sue thousands of individual XRP holders, which is way more uncommon than an interlocutory appeal. She then later denied the motion to intervene, but allowed me to serve as amicus counsel instead. Here's another comment from Attorney Deaton. From the first day this case was filed, I said charging the individual defendants with aiding and abetting in a non-fraud case, and thus increasing the burden of proof, was outright stupid. It was the brainchild of Jay Clayton and Bill Hinman, once again, proving that those two were not making decisions based on the law and justice. Clayton is on video with Joe Grunfest saying how he likes to charge executives because it changes the dynamics of the case. In other words, it scares and intimidates people. The decision to sue Brad Garlinghouse and Chris Larson was for the wrong reasons, and that dumb decision is costing the SEC. Quote, the SEC's anticipation that it might later wish to pursue a different litigation strategy because it finds it difficult to prove its far-fetched aiding and abetting claim does not justify a stay, end quote. Then there was this from Attorney Hogan. He wrote, Ripple makes solid arguments why the appeal shouldn't be allowed. But if it is allowed, Ripple is going to get its contractual obligations argument in front of the Second District Court of Appeals, and that will be something. I'm talking amicus briefs raining from the heavens. And that would be fascinating. And he highlighted this part from Ripple's brief, which reads as follows. By contrast, defendants raised a legal question about the scope of the term investment contract, as construed in Howey, and whether it can be applied where there is no contract between the buyer and the seller that grants rights to the buyer and imposes obligations on the seller. If the SEC is permitted to appeal, defendants will seek to cross-appeal on this issue, as well as the fact-bound portion of the court's order finding liability for certain transactions. And so this was actually retweeted ultimately, I think, here, by Bill Morgan, Attorney Bill Morgan. And he noted the following regarding that, because he's talking about on-demand liquidity transactions. Because as you are aware at this point, undoubtedly, Ripple didn't get a 100% win. Now, they did get a win, obviously, on the part that really mattered, on the topic of whether or not XRP itself is a security. But there are certain institutional-level transactions where Judge Torres did not rule in favor of them. So what does this mean for on-demand liquidity? Well, Attorney Morgan wrote the following. Also flagging an appeal on certain of the liability transaction which, as I have gone on about for weeks, must include sales to on-demand liquidity customers depending on the contract terms. Attorney Fred Rispoli wrote the following. With Ripple, Brad Garlinghouse responses, I did okay. Correctly called, Ripple would oppose appeal, but would seek to appeal its loss should court certify appeal for SEC. Ripple would throw up all the factual issues that make interlocutory appeal messier, not cleaner, than a normal appeal. and that Brad and Chris would emphasize their desire for speedy resolution and oppose a stay. I was wrong on Ripple proposing a lengthier briefing schedule, as it did not object to the one proposed by the SEC. I predicted that Judge Torres will permit normal briefing on the issue. Still favor this as most likely, but after reading the defense responses, I'll increase the chance she denies even briefing for interlocutory appeal to 30%. Should get a ruling fairly quickly on that. Man, it would be great for a quick slapdown go XRP. Yeah. And so obviously we now know that this has been approved to go forward, which again, I don't know. I'm not even going to make a prediction. I'm not an attorney. I don't know if the judge is actually going to approve this, but I did find Attorney Deaton's perspective interesting that, should it go that route, it could change the dynamics to the negative for the SEC. And then there was also this, a little less than an hour ago, Attorney Rispoli wrote the following. Request to file motion for leave to file interlocutory appeal granted. Briefing schedule will be as requested by SEC and unopposed by Ripple. Motion due tomorrow, Ripple response due September 1st, reply due September 8th. Would expect decision within 30 days after that. So it's all kind of coming to an end here. This is not going to go well for the SEC. This is definitely not. They can do whatever they want. They are just in absolutely devastating defeat right now. This isn't going to do a thing to change anything to the negative for any of us listening, and that's just a beautiful thing. Because seeing BS tactics like this from the SEC for over 2.5 years, we never knew for sure along that route what that might mean for us as XRP holders. But now that that's been cleared up, I just don't give a damn. So do whatever you want here. This is not going to go well for you, SEC. You're just going to keep losing because you have overreached. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.